from our witnesses. And first of all, just apologize. We're a little late because we had votes today and interest, so we might have to be a little shorter. The first panel, I'd like to introduce Superintendent Lisa Byrne of the Canadian Association of Chiefs of Police for 5 minutes, and I believe they will be splitting their time in the next. The Canadian Bar Association would be next, and that's Janine Grunberg, Chair of the Municipal Law Section, and Kevin Westall, Secretary of Criminal Justice Section. So we'll begin by Canadian Association of Chiefs of Police for 5 minutes.
Good afternoon, everybody, and thank you for the opportunity to address the committee on behalf of the Canadian Association of Chiefs of Police. Human trafficking investigations and prosecutions require significant victim participation. This leads to the re-victimization of individuals who have to retell their stories and relive their experiences on multiple occasions. While police in Canada focus on trauma-informed practices, the nature of the system required to hold offenders accountable is adversarial, difficult for victims to navigate, and is not victim-centered. The primary goal should be to fully support victims who are often children and vulnerable individuals. This may include helping the victim leave the exploitive situation, but this often happens in the absence of criminal charges or offender accountability. A significant strategy employed by police to combat sex-related human trafficking is to hold offenders accountable in court by relying more on corroborative evidence and less on direct victim testimony. The commodification of sexual activity and related sections of the criminal code are useful for police to combat sex trafficking. For example, in 2018, the Vancouver Police used Section 286.1 Sub 2, which is obtained sexual services for consideration from persons under the age of 18, to arrest and convict 24 individuals who made efforts to purchase sex from children. In 2020 and 2021, the Ontario Provincial Police charged 26 males and 2 females with a variety of offenses related to sex trafficking and trafficking in persons, including material benefit, procuring, and advertising sexual services. Police agencies use these offenses to focus on offenders, often the buyers of sex and the profiteers of human trafficking victims. These offenses may or may not require evidence in the form of victim testimony. They are often supported by corroborative evidence that the police can obtain via the use of search warrants, production orders, and other evidence gathering techniques. For example, I am aware of an investigation in southwestern Ontario in which a 17-year-old victim of sex trafficking never provided a statement to police. Despite offers of support to the victim, the combination of her fear and personal vulnerabilities prevented her from ever giving a statement. However, the police were able to collect sufficient evidence to arrest the accused. A warrant was obtained to search the phone that the accused had on his possession upon his arrest. The evidence contained within it, along with the corroborative evidence from the victim's mother, were sufficient to prove a procuring charge. The offender pleaded guilty and received a jail sentence. The offenses under Section 286 of the Criminal Code led to this offender accountability, whereas the same evidence without victim testimony would not have been sufficient to prove a human trafficking charge to the requisite standard in criminal court. In addition, where human trafficking and offenses from Section 286 are laid in the same case, the legislation being studied provides much needed flexibility in developing a prosecutorial strategy when victim testimony is or becomes unavailable for a variety of reasons. The Criminal Code also provides exceptions to those who provide their own sexual services, whether independently or cooperatively, as long as the only benefit received is derived from the sale of their own sexual services. The exceptions codified in law under Section 286.2 Sub 4 and 286.5 extend to those who assist others in the sale of their own sexual services, for example, in keeping them safe, and derive a financial and material benefit as long as there is no exploitive relationship. As a result, the police are not laying charges in these circumstances. The Ontario Court of Appeal recently upheld the constitutionality of the relevant offenses and further defined the exceptions in a case called Regina versus NS, and the citation for that is R versus NS 2022 Ontario Court of Appeal 160. I encourage the committee to reference this case as part of your decision-making process. The law, as it is, does not permit the police to target individuals who provide their own sexual services, and those who receive financial or material benefit from non-exploitive situations. The focus of the police has been to target predatory offenders and organized crime groups who exploit vulnerable victims. The legislation being studied is an essential tool for the police to ensure the safety and security of children, vulnerable adults, and victims of crime, and where appropriate, prosecute offenders who exploit them. The CACP recommends that the current statutes be maintained and is not advocating for change. Thank you.
Thank you. I now give 5 minutes to the Canadian Bar Association, so I think they'll split that time amongst themselves. Over to you.
I can begin. Can everyone hear me? Thank you. Good afternoon to the chair and the honorable members of this committee. My name is Kevin Westell. I'm the secretary of the CBA Criminal Justice Section and a criminal lawyer currently practicing in BC, the traditional territory of the Musqueam, Squamish, and Tsleil-Waututh nations. I'm coming to you from there now. Thank you for inviting the CBA to discuss this particular act. Ms. Grunberg is here and we'll split time. She'll go after me. She's from the municipal law group. My perspective is from the criminal group. The CBA is a national association of 36,000 members, including lawyers, law students, notaries, and academics. And our mandate includes seeking improvement in the law and the administration of justice. And one of the things that the CBA section prides itself on is that our membership comes from both the Crown prosecutors of this country and members of the defense bar, and also members of the bars of this country who act for vulnerable witnesses as well. And as such, we say we bring a unique and balanced end user perspective to the system. So the comments I raise on behalf of the criminal lawyer's perspective concern the extent to which this legislation is really built to meet the overarching aim of the act as set out in the DOJ's 2017 technical paper, namely to strike a balance between the interests of two vulnerable groups, those who are subjected to prostitution and children who may be exposed to it. I'm going to talk first about Section 286.1 of the Act, which criminalizes the purchase of adult sexual services, including consensual and non-exploitative transactions. While the act of selling sexual services is not criminalized, the very fact of the criminalization of the purchase of sexual services maintains a risk of harm to vulnerable sex workers within our populations. We feel that section should be removed altogether. Section 286.1 we say is arbitrary, grossly disproportionate, and overbroad in that it captures non-exploitative consensual sex work in the net of criminal liability and prevents sex workers from availing themselves of protective measures. Sections 286.2 and .4 also pose safety risks. Restricting sex workers' ability to advertise limits their access to clientele, forcing them to conduct their business in public locations rather than in safe indoor environments. Restricting the ability of sex workers to hire employees, such as bodyguards and executive assistants, by making them vulnerable to criminal liability, severely limits the ability of sex workers to protect and organize themselves and grow their businesses with a recurring clientele in safe, secure locations. Charter challenges based on that notion, or the notion that such concerns have led to superior court rulings that the sections I've mentioned are unconstitutional. And the sheer volume of litigation dealing with the breadth of these provisions and its impact of their constitutionality militates, we say, for amendments narrowing those provisions. Finally, from the criminal perspective, is the issue of mandatory minimum sentences. At its 2021 AGM, the CBA adopted a resolution urging the federal government to eliminate mandatory minimum sentences for offenses other than murder, and to include a safety valve for offenses where mandatory minimum sentences remain. The mandatory minimum sentence implemented by this act are vulnerable to constitutional challenge, and the CBA sections recommend their removal. The Ontario Court of Appeal in Regina and Joseph recently ruled that the mandatory minimum sentence required by 286.2 is unconstitutional and of no force and effect. Maintaining these mandatory minimum sentences mandated by the Act runs contrary to its broader, high-minded purpose. It prioritizes the protection of vulnerable populations from exploitation. Mandatory minimum sentences have consistently been shown to exacerbate the exploitation of vulnerable populations, and in particular, Black, Indigenous, and racialized populations. Further, and as noted by the Public Health Agency of Canada, Indigenous women, Those who are most likely to be affected by mandatory minimum sentences are also disproportionately overrepresented in sex work. Imposing mandatory minimums on those who communicate for the purpose of securing sexual services negates the self-determination of vulnerable and marginalized people over their own bodies, further marginalizing those individuals. This is opposite of the effect intended by the legislation. I thank you for your time and I welcome any questions the committee has when it's my turn. Over to Janine.
Quickly, Janine, you'll have 30
Thank you.
seconds.
I'll hit the high points. Firstly, we're recommending that there be revisions to add definitions to section 213 sub 1.1, the offense respecting communication to provide sexual services by the seller. Secondly, we recommend that that same prohibition be extended logically to other situations where children frequent. School grounds, playgrounds, and daycare centers are mentioned, but this should be extended to other situations or other locations such as swimming pools, recreation facilities, and shopping malls. Thirdly, we would encourage the committee to pursue more grassroots consultation. And fourth, we recognize that since Bill C-36 became law, the final report of the National Inquiry into Missing and Murdered Indigenous Women and Girls has been released. For your ease of reference, we have attached the relevant calls for justice, and we encourage you to reference those calls for justice when you're deliberating on the future changes. Thank you very much for the opportunity to present.
I'll now, hopefully you'll be able to finish off anything else you had to say in one of the questions. I'll go to the first round of questions for 6 minutes, beginning with Mr. Cooper.
Thank you very much, Chair. Thank you to the witnesses, and it's very good to see my former colleague, Ms. Grunberg. Welcome. And I will allow you to maybe carry on from where you had left off, but before I do that, in your brief, you mention Section 213 and the definition of public place, in which you characterize it as circular. Perhaps if you could elaborate on some of the issues that you see with the definition and changes that could be made to provide greater clarity.
Thank you very much, Mr. Cooper. Just to provide the context, there are 3 different prohibitions relating to communication. Firstly, under section 213 sub 1.1, this is the prohibition relating to the seller, and this is the section that we focused on primarily in our submission. So that prohibition prevents the sex worker from offering or providing the sale of sexual services in a public place or a place open to public view that is or is next to a school ground, playground, or daycare center. The definition in section of public place in section 213 sub 2 only applies to that section, but as I mentioned in our written submission, it's somewhat circular. It simply says that a public place is essentially a place to which the public is invited. So the definition doesn't really provide, if you will, any meat or any additional context. Then there is the prohibition relating to traffic impediment, and under section 213 sub 1, that applies to both the seller and the purchaser. Now, with respect to section 286.1, the main section relating to communications, that applies to the purchaser, and it is broader in that it says that it is an offense to communicate with anyone for the purpose of obtaining for consideration the sexual services. But there are 2 tiers, if you will, of offenses: a generic offense for summary conviction, and of course for a more serious offense, an indictable offense, a communication that is a public place or in any public place open to public view that is or is next to a park or the grounds or school of a school or religious institution, or that is or is next to any other place where persons under the age of 18 can reasonably be expected to be present. So for the purchaser, if you will, the communication has a broader location and includes locations where where children under age of 18 can reasonably be expected to be present. But for the sex worker, it is narrower and tied to, at present, the public place or place open to public view, that it has those three qualifiers: school ground, playground, or daycare center. Now, the problem with those three terms, as they apply under section 213 sub 1.1, they're not defined. So for example, a term like playground might seem self-evident at first blush. Well, what does that mean? Is it a place where what might first come to mind is where there's slides, monkey bars, etc. Well, does that mean that that's restricted to an outside event, or is it someplace that would be also included within a recreation facility? These things simply aren't known. And where there's ambiguity in terms, there's difficulty both with respect to compliance and enforcement. We have in our paper outlined some case law, not directly relating to the sections post 2014, but cases that have struggled with this issue of what is meant by public place. So we would leave those for your consideration, because it does show that the courts wrestle with this.
Great. Thank you for that. And you briefly touched on it in your very short time that you had to present about extending the prohibition on communication under Section 213 1.1 to include additional lands that children frequent, I guess on the basis that there doesn't seem to be a rational basis to, on the one hand, include school ground, playground, or daycare center, but then exclude places like swimming pools and public parks where children also frequent.
Yes, precisely. There doesn't seem to be a rational explanation. We don't know why those three specific locations were chosen: public parks, swimming pools, and school grounds, playgrounds, or daycare centers. So it does seem like it would be logical to extend the location to other places that children would frequent.
Thank you.
Time, Chair? Time out. Okay.
Your
Thank
time.
you.
Thank you, Mr. Cooper. Next, Mr. Nakvi for 6 minutes.
Thank you very much, Chair. Can I go back to, I think it's Inspector Byrne? If I can, sorry, I may be getting your title wrong. So I just wanted to perhaps start with the experience of policing around enforcement of this legislation. And if you have some data from the Canadian Chiefs of Police, that will be very interesting to know, since the enactment of this legislation, what has been the experience in terms of enforcement, what have been some of the deficiencies or challenges that you may have faced with enforcement of this particular piece of legislation?
I don't have statistics readily available, but I would be happy to supply them at a later date if that is acceptable. But I can really, as I said in my statement, our difficulties in enforcement really do involve having the victim come to court and getting that statement from the victim. It is very difficult in the human trafficking charges to get a victim on board and have a victim attend court. There's multiple vulnerabilities. And when we're dealing with high-level criminal organized groups in particular, there's additional threats to the victim that make it very difficult to bring that person to court. Additionally, when we do enforcement, the more offenses we have, if we think of the offenses as a tool, we can use these offenses, and these will not necessarily be the charges that we lay in the long run, but the offenses are tools to obtain and gather evidence. We use them to seek judicial authorization, for example, search warrants to search phones and to gather other corroborative evidence that we can either use to corroborate the victim testimony or instead of the victim testimony. Our goal is not to target individuals who are selling their own sexual services. Our goal is really to target offenders who are exploiting vulnerable victims, and then to also target the buyers of sex who are being exploitive, particularly around children. So those are some of the prevailing strategies that you will see with police across the country. Let me know if that answers your question or if I can clarify.
Yeah, I want to further probe the point you just made, which was around that your aim is not to go after people who voluntarily offering themselves as sex workers versus those who may be exploiting. How do you make that distinction from a law enforcement perspective?
Well, from the law enforcement perspective, typically when we enter into an investigation, it usually involves a complaint that comes in via a complainant, a victim, or a witness. And it often will involve something to do with violence or some other overt act. Typically, those who are involved in their selling of their own sexual services, if it's peaceful and consensual, that does not come to our attention. So we're not proactively targeting people who are selling their own sexual services. I would argue we're more reactively investigating when there's additional offenses or concerns such as violence, intimidation, coercion, children involved. Those would be sort of the differentiation. So we're not proactively targeting those who sell their own sexual services in a consensual manner.
Has it been your experience that one of the side impact of this legislation has been that those who are involved in sex work have gone underground because they're concerned that they may be targeted as a result of this particular law?
I cannot in good conscience speak for the entire country with that regard, but I can tell you here in Vancouver, that is not my experience. The Vancouver Police Department does have a very good and open relationship with the sex worker community in Vancouver. I do not believe they have gone underground per se, and they certainly don't fear enforcement from the Vancouver Police Department specifically, because we just simply aren't doing it. We are tasking and enforcing where there's other concerns, like I've already mentioned, violence and organized crime and exploitation of children.
We've heard from some during this committee that the legislation allows better protection for those who are in sex trade industry. Has that been your experience as law enforcement, that it does allow for that protection or not?
I would say yes, it does allow for protection in the sense that a legitimate lawful brothel owner where there is no exploitation whatsoever and they're operating within the law, that allows the protection for not only the operator but the women working in that situation. The law also, the way it stands, allows for protection of the vulnerable people because we have the tools necessary to actually engage, initiate, and carry on with those investigations with the hopes of getting criminal charges. And as I said in my statement, that's not always what happens. Often the success in these investigations is the extraction of the victim, who is mostly female, from the situation and getting her to a safe environment. The criminal charges really can be secondary sometimes to that primary concern of the victim wellness.
Thank you. Mr. Chair, if I may quickly ask a question of Mr. Westill. And my question was, does the Canadian Bar Association has any position on decriminalizing sex trade in Canada, something akin to New Zealand?
I would say at this point, we've not gone that far in any of our positions. I would say that we are concerned about, I think the closest we come to that position is the position I pointed out with Section 286.1, that we don't believe that position should be in there at all. We don't believe that the purchase of sexual services without any qualifications for exploitative circumstances should be criminalized, that it just poses more problems. It doesn't add anything. It doesn't do anything to protect Canadians. And we believe that and I don't mean this in any crass way, but when we say that sex work is the world's oldest profession, there's a reason for that. Sex work is going to continue to go on. There are going to continue to be those that sell it, and there's going to continue to be those who purchase it. And for that reason, there's really no public interest in criminalizing its purchase.
Thank you. Thank you, Mr. Naqvi. Next for 6 minutes, Mr. Fortin.
Monsieur le Président.
Mr. Chairman. I'm sorry, I have to put my glasses on to read properly. Mr. Westall, I was wondering, I understand that the Canadian Bar Association considers that criminalization of prostitution will not necessarily be helpful. But how far would you be prepared to go? Because we understand that sexual exploitation of minors and so on, I didn't hear anyone consider that as being proper and something that should be legalized. But when we talk about prostitution between consenting adults, some people will tell us that it should be decriminalized and allowed, and others who say no, it has to remain a criminal offense. So there's the whole issue of the people working around them. But how far does the CBA think we should go in a potential process of decriminalization? What are the behaviors that should remain criminal offenses, and what are the behaviors for which we should be more permissible, let's say?
I hate to be repetitive and go back to my previous answer, but it's my sense that including a provision that makes the purchase of sexual services in general a crime doesn't really do any good, because it's not narrowly focused enough to get at what we're concerned about. It's inherent in your question that the concern is not the purchase of sexual services by two consenting adults. The concern is the exploitative relationships that can evolve and have evolved from these contexts over history. So we're talking about, we should be criminalizing any involvement of children in the sex trade whatsoever.
Madame Byrne.
Thank you, sir. Ms. Byrne, I'm asking more or less the same question of you. In your opinion, how far should we go? What are the limits that should be set in a potential review of the Act? And is the criminal code not sufficient, or does it not have enough provisions that can frame this kind of prostitution activities? I'd like to know what you think, because I'm under the impression that we need some explanation between the law and what's in the criminal code and what limits should be imposed.
Thank you. Yes, I think, I don't envy the minister's position of striking this balance, because really it is a balance between adult consenting sex workers and those who use the sex work industry to victimize and exploit individuals, including children. So it's a very difficult balance, and I don't envy your job. At the moment, the Canadian Police do believe that the criminal code is sufficient, although I do hear my colleagues in their comments, Mr. Wessel and Ms. Grundenberg, and I can also understand their points of view. What I think that could be elaborated on in the criminal code is perhaps thought put to offenses where we do not need to re-victimize or do not need victim engagement. And, I don't pretend to actually be able to give you some legitimate answers today, but some thought and discussion around, are there additional offenses that we can add where we really do expand on the definitions of the involvement of organized crime, for example, the involvement of violence, the involvement of children, and any offenses that could be more well defined in those broad victim categories, and perhaps look as well at the exceptions and see if we can.
If I could interrupt you, I have little time. I understand what you're saying, but it's really on the issue of prostitution. Does the association or has the association looked at what's happening in other states in terms of decriminalization? And if so, what are the aspects of decriminalization that you would be comfortable with?
Position again to answer that for this Canadian Association of Chiefs of Police. Certainly here in British Columbia, we have looked at different models, the Nordic model, for example, and we have created enforcement guidelines with respect to that model. But again, I can't specifically speak for the Canadian Association of Chiefs of Police. I apologize.
Qu'est-ce que vous répondez?
What would you say to the prostitutes who tell us that it's difficult for them, sometimes it's men, to speak out against a pimp, given the provisions of the law? Is there a solution to that difficulty? In wishing to protect, we create a situation where it becomes hard for people to speak out against those.
Position, and whether it's a man or a woman, it's very difficult to speak out against a pimp and to testify against them because it creates inherent danger, particularly, again, as I've mentioned, a lot of the pimps that I am aware of and have done investigations on are part of organized crime. So it carries on a much more significant threat as well. I think that is the crux of the problem. How do we have victims come forward and testify and protect them and not have to re-victimize them in the current system where it is an adversarial system?
Mais est-ce que la décriminalisation...
But would decriminalization not indeed have the effect of helping them? I'm sorry, I've run out of time now.
Just out of time there. Mr. Garrison for 6 minutes.
Thank you very much, Mr. Chair. I want to turn to Superintendent Byrne and just ask about a certain contradiction I seem to hear in what you're saying to us. So you're saying that you don't enforce certain sections of this law, but you need to keep them because you need to use them against trafficking. So to me, that seems a bit contradictory. If we have a problem in prosecuting trafficking, shouldn't we improve those sections of the criminal code rather than trying to use sections of the criminal code that you think are actually not necessary when it comes to sex work?
It's not that I don't think they're necessary. I don't think they're necessary for particular demographics, but I do say that they are necessary for the enforcement on the vulnerable victims and those in exploitive situations.
But essentially you're saying those who are being trafficked and exploited, you need it for those. So don't we actually need better laws to deal with trafficking and exploitation rather than generalized laws dealing with sex work in general?
Perhaps, but I would be reluctant to remove some of the sex work aspects of them because as police in Canada, it can be very difficult to gather the requisite evidence. And like I said, the more tools we have at our disposal, and often that comes in the form of a variety of offenses that may not be the ones we actually lead to prosecution, the more success we will have in our investigations.
And you say, of course, from your experience in Vancouver, I know that's true in Vancouver and Victoria, that these sections that are somewhat problematic, especially those about where sex work can be practiced in public and about the ancillary services that might make it safer, those aren't enforced in Vancouver and Victoria, but they are enforced other places in Canada. So if we leave this in place, are we then saying it's up to the discretion of police forces whether or not these are useful things to have?
I would encourage the group to come up with legislation that can be applied throughout the country. And I do understand that it is a much more different demographic of enforcement here in British Columbia. And I know we've been working very hard, including with the British Columbia Chiefs of Police, on enforcement guidelines and the provincial government as well. So perhaps enforcement guidelines, they do become somewhat subjective across the country, and a stronger legislation would be helpful for police as well, a more concise and concrete legislation.
So we've heard testimony, quite a bit of testimony actually, in this committee from those who are involved in sex work and from sex work advocacy organizations, that in particular, those provisions that make it illegal to, I guess, solicit, I'll use that word even though it's not the word I like, sex work around certain public institutions forces sex workers into unsafe situations in municipalities. Would you agree that that's the case? If those sections are being enforced, it puts sex workers in more vulnerable situations by making them work in isolated places?
I'm sorry, Minister, I can't really comment outside of what my experience here is in the Vancouver area. I would be reluctant to comment on a rural situation, for example, that I'm unfamiliar with. I could only speculate that if that's what they're telling you, then perhaps there is legitimacy to it, but I can't give you an example or any legitimate opinion on it.
Okay, and in the same sense, we've also heard from those who are advocates for sex workers about the use of the Immigration Act and the prohibition of migrant workers being involved in the sex trade as creating an extra vulnerability that prevents migrant workers who might be subject to violence or being exploited from approaching the police because they could end up being deported from Canada. Have you found that to be the case in your work?
No, not at all in my work. And in fact, as part of our guidelines, we do not seek immigration enforcement. We want it to be very victim-centric. So no, not here in British Columbia.
So again, that's part of the guidelines of the British Columbia Association of Chiefs of Police rather than an impact of the law?
Correct.
Great. I have a question. I know I'm going to run out of time fairly soon, but from Ms. Grunberg, I'd like to know, I wasn't very clear who you're speaking for today.
Thank you very much. I speak for the Canadian Bar Association National Municipal Section. As was referenced earlier, the Canadian Bar Association is an umbrella organization covering the entirety of the province, or the entirety of the country. The municipal section itself includes both private practitioners, lawyers, and in-house lawyers for municipalities from across the province. We were able to draw on the collective experience of our 20 executive members, which span the country. And as I mentioned, both private practitioners doing work for municipalities and in-house lawyers.
And so these recommendations that you brought to us are from the executive of that branch of the Canadian Bar Association, is that correct?
Yes, that's correct.
And has there been a broader discussion in the Canadian Bar Association about those recommendations? Because they contradict a lot of the evidence that we've heard here about safety of those involved in sex trade.
No, we were not able to do further consultation. And in fact, our third point is that we encourage the committee to do broader consultation in that regard. We did not have an opportunity because of the timeframes involved, for example, to consult with the Federation of Canadian Municipalities or the provincial municipal associations.
Thank you.
Great,
Thank you, Mr. Garrison. Now for 5 minutes to Mr. Morrison.
Thank you, Chair. For Superintendent Brian, I'm just wondering, and this has been touched on by a couple of questions, but as part of BCACP and CACP, how could you, in your opinion, move forward with standardizing how success you've had with enforcing PSEPA in Vancouver and British Columbia to have the same type of success across Canada?
I think to do that, it would require the various police agencies. And in preparation for today, I actually spoke to a variety of police agencies across the country to reach a consensus. And I think we really have to look at the two different types of environments that we do find in Canada, the rural versus the urban environment, because they can be very different. However, we have had success here with our enforcement guidelines, and we engaged the sex worker community group to give us input and assistance on developing them. And we do seek constant feedback on them and adjust as necessary. So I think it would be something that would require collaboration of all the police agencies, and then also with the Crown as well, and other stakeholders involved in the criminal justice system.
And another, on top of that, another success. I can tell by your compassion that you're giving to us and your experience. It's come across our I guess our desks during this investigation we're working on, some inconsistencies of how the different police departments are actually handling the sex workers, and it would seem to me that on top of perhaps standardizing the enforcement side, but also to have some standard training so that, you know, other law enforcement agencies that are struggling with getting, you know, having people come forward because they're afraid of police, which, you know, I've got a fairly extensive background in policing, and sometimes it just takes a long time, but also takes the right people to develop training. I wonder if you can help us in some suggestions on where we could go, you know, nationally to ensure that we have police officers in enforcement trained to that degree to be sensitive and to be using common sense.
Yes, thank you, Minister. I would suggest a national training. Of course, we do have access to the CPKN, which is a national platform that police can receive training on, mostly online. The one thing I do want to point out, though, because yes, the law is enforced differently throughout the country, but the demographic of the crime groups are also very different across the country. So that is a challenge for us. In the East, gangs such as the North Preston's Finest are very, very entrenched in organized crime and the exploitation of women and children involved in the sex trade. We're only beginning to see that here in British Columbia. So I just want to make the ministers aware that that is an issue as well. Not only is the enforcement different from region to region, the crime groups who are actually committing the offenses are extremely different as well.
And maybe just touching on organized crime, gang activity, what have you seen in recent times, maybe in the last 2 or 3 years, as far as children, especially children being exploited, you know, involved in the sex trade, you know, by organized crime and gang activity? Have you seen a change in that at all?
Yes, Minister, we have seen a significant change here in Vancouver. I think it's something that is much more common in the East, in Nova Scotia and Ontario particularly, but here we have seen the recruitment of young women in malls and in high schools by young men who are 12 to 15 years old and acting as pimps. So obviously very concerning on all fronts, where the offenders are young and the victims are young, and it starts at a very early age.
Okay, thanks very much.
Thank you. And now I'll go over for 5 minutes to Madam Diab.
Thank you very much, Mr. Chair. I'm going to direct my question to Mr. Westall for the criminal justice section. Really interested by, and I would like to get a little bit more in depth on what my colleague there, Monsieur Fortin, was asking you and your responses to that regarding sort of, I guess I appreciated when you started with that the Canadian Bar Association has a unique and balanced perspective, and you know, having been a member of the CBA more than a decade ago for many years, certainly, you know, I can speak to my involvement when I was there at the time. So, but in relation to what we are dealing with, I would appreciate from your section, your perspective, and to sort of elaborate a little bit more on that. And then as well, can you comment whether or not you would have looked at, or your section would have looked at all at the New Zealand model? And, you know, just for the purposes of the committee here, we're trying to figure out what to do with this, whether to strike this bill, whether to leave it as is, whether to make amendments, and if so, what, and how to help sort of, you know, the issues here. And I'm, you know, going to agree with a number of things that you said. There are other provisions in the law that deals with human trafficking, etc. So what are we trying to do here, and what is your recommendation to us?
Well, I'll plead right off the bat, I'll enter my plea that I don't have a working knowledge other than a very broad one about what they're doing in New Zealand and its efficacy and its implementation. So I'll have to pass on that aspect of the question. You just in facing up to the rest of the question, I'll say that we are an organization of lawyers, and our section is made up with Crown, Defense, and as I said, those that work and specifically do files on behalf of vulnerable people, including victims of sexual offenses. And all those perspectives are at the table when we formulate our position on things like this. And I would say also, there's the doctrinal aspect of this that is principle. What are the principles that should govern our position? But there's also the question of what's practical. And practically speaking, when bills or provisions are designed too broadly, they lead to constitutional challenges that have merit, whether they're successful or not. And that takes time and money in our courts and costs the taxpayers money. So we want not only fair and just laws, we want precision in lawmaking. Precision keeps us away from constitutional challenges because the net of liability is cast too broad, for example, on certain offenses or certain criminalized portions of an act. And we want to, and that's really a lot of what we're concerned with here is with 286.1. It nets in people that are not, whether in theory or in practice. It's easy to see that those that are not what we would classically define as the exploited sex worker, the underage sex worker, they are made to suffer and they're put at risk by elements that make it hard for them to have transparency around the work they're doing. If they have to hide any of it, we say that pushes this underground. With respect to 286.1, we say strike it. With respect to 286.2 and 286.4, we need to make it more specific. That's what we're asking.
So would you say Canada's prostitution laws are being used as an indirect way to prosecute human traffickers? And if so, should they be?
Well, I think the human trafficking provisions should be used to prosecute human traffickers. If a human trafficker or somebody engaged in the work of human trafficking contravenes these other laws, then they should be made to be accountable to these laws as well. There's no problem with that. But to say, again, specificity and precision is going to assist lawmakers, it's going to assist courts and prosecutors.
With 30 seconds, what changes would you make? What would you recommend?
286. We say 286.1 should be struck. 286.2 and 286.4 should be made more narrow, and it should be delineated to make it very clear that it's not meant to. It should not be banning the use, for example, of those that become a party to sex work through providing pro-social measures to make sure that sex workers are able to work safely and appropriately privately.
Thank you very much.
Thank you, Madame Diab. Now for 2.5 minutes to Mr. Fortin.
Merci, Monsieur.
Thank you, Mr. Chairman. I'll come back to you. I'm sorry, Mr. Westall. And quickly, because we don't have a lot of time, I only have 2 minutes, you've heard. I'd like to hear you. Ms. Byrne said that she saw that some criminal groups and organizations were involved in the sex industry and that were even at people as young as 12 to 15 at school that were working as pimps in this industry. So when we talk about people under the age of 18, this is another story. We understand that the provisions are not the same. But generally speaking, if we put that aspect aside, for criminal groups, in your opinion, first of all, what is the difficulty for you representing the Canadian Bar Association? What is the main problem that prosecutors are faced with when they're trying to prosecute pimps that are members of criminal organizations? And secondly, in your opinion, would there be any way of strengthening the existing legislation to allow it to be more effective and more punitive when we're talking about these kinds of criminal organizations?
Ultimately, again, it comes back to precision. And these, in terms of combating the types of pimping type behavior that was mentioned, there needs to be precision, and there needs to be precision around the concepts of coercion and exploitation. The offenses and the criminalization that is brought to bear through this act needs to narrow in on those elements.
Mais pour les
And not
groupes
be so-
criminels, les organisations,
But for criminal organizations, do you see anything that specifically we should be targeting?
We should be targeting exploitation, and we should be targeting coercion, and we should be utilizing the criminal organization provisions of the criminal code in addition to these provisions when we prosecute those particular individuals. There's offenses that can be added on when offenses are committed for the purposes of a
merci.
criminal
Je m'excuse
organization.
de
Those
vous
should be
bousculer,
utilized.
Monsieur Wessel.
Thank you, Mr. Westall. But I have little time. Currently, in your opinion, are the lawyers working on these files using those criminal code provisions on these organizations, or is it too difficult?
I've had lots of experience seeing prosecutors utilize the CrimOrg provisions of the criminal code. They're there to be used, and they should use them.
Thank you, Mr. Fortin. Now for 2.5 minutes to Mr. Garrison.
Thank you very much, Mr. Chair. I want to continue with Mr. Westall because what I was getting at earlier, I think with Superintendent Byrne, he's really addressing here of using certain sections of the criminal code as ways of getting at real criminal problems. And I think I just want to make sure I'm not misinterpreting. When you're talking about precision, you're talking about that difference of the police using some of these general provisions on sex work to get at trafficking and exploitation. Is that correct?
I'm talking about precision in the way that we word these provisions so that they capture only what they're meant to capture and not beyond that. The CBA doesn't have a problem with these provisions being used against the bad actors that they're intended to catch. The problem is that if it's broad enough to capture those other than if the provision is struck in a manner that's broad enough to capture offenders or potential offenders beyond those bad actors, beyond those criminal organization members, then mischief can be made and challenges will be brought in the courts and taxpayer money will be spent litigating something that could be solved at the root, at the drafting stage.
And I guess the other contradiction I'm seeing today is between the two people who appeared from the Canadian Bar Association who seem to be presenting radically different approaches to this law. So if we look at what Ms. Grunberg has suggested in terms of the public places definition, she's actually suggesting expanding those provisions further than those which currently exist. So are those provisions some of the ones you're talking about where we need to be more precise? Because my understanding is they apply around the clock whether children are present or likely to be present or not. The current provisions are actually the ones that drive those who are forced to work on the street into unsafe conditions. And so we've got one part of the Canadian Bar Association saying those should be expanded. And I guess I'm asking, it doesn't seem like you're in favor of that.
No, I'm not. We're not at odds on that point. I mean, there's no public interest in having sex work occur in these public areas that are designated for children and families and certain types of uses. But if they're going to do that, if we're going to do that, and quite rightly carve away those opportunities for sex work to occur there, we need to allow other provisions to give way so that it's easier for hotels to be used and Airbnbs and places like that. Right now, if somebody engages in allowing an Airbnb to be used for that purpose, they're a party to the purchase of sexual services and a party to a crime.
Thank you.
And so we're saying that we can expand it, but we also need to expand the private spaces as well.
Thank you. Now for the next round, and just in the interest of time, I'm just going to ask if we do them for 3 minutes each rather than 5 minutes, if that's okay. Mr. Brock for 3 minutes.
Thank you, Mr. Chair, and I want to thank all the witnesses for their testimony and cooperation in answering questions from my colleagues. I'm going to focus with the time that I do have on the Superintendent Byrne. Superintendent Byrne, as a new parliamentarian, I was I was intrigued by your summary of evidence. I read that very carefully. I left a 30-year law career, the last 18 of which I was a Crown prosecutor. I do appreciate your commentary with respect to the challenges in prosecuting matters. But that won't be my focus. My focus is really one of the elephants in the room that we've dealt with over the course of several weeks. And I'd like your perspective from law enforcement as to what type of Canada would you envision should this committee and ultimately the government recommend repealing this particular bill. And before you answer that, we've heard from a number of witnesses that one in particular brings to mind her commentary that Canada would turn into the brothel of the North, that it would be a free-for-all for the sex industry. So I'd like to hear your perspective as a experienced police officer on that question. Thank you.
Thank you, Minister. I'd also like to add my perspective as a female to this. I would like to see a Canada where we have a very balanced approach, where women have the right, or men in some cases, although it's mostly women, to engage in activities that are lawful to support themselves. However, we need to strike that balance somehow, because the sale of sex and sex itself as an industry can be used in a very negative way. And I've already described all these situations. So where I see Canada going is finding that balance. I think we're a country that can do that. I think we can look at examples from the rest of the world and really strike and achieve that balance, perhaps with new legislation, modification of this legislation. However, I don't think we can lose as the police. We have so many challenges in our investigations, and I'm sure the Crown prosecutor and you as a former Crown will understand, with constitutional challenges, not even related to sex work, such as R versus Jordan, and certain disclosure issues, and just the burden of proof required in criminal court that has only grown in the 20 years that I've been a police officer, that these investigations can be very complicated. And you start to talk about using other sections, such as the organized crime section. I've been the team commander on organized crime investigations. These are multi-year investigations with multi-year prosecutions in the hundreds of thousands, if not millions of dollars. So is that realistic for us to achieve in every instance, to balance the public safety that we're trying to achieve here? So that is what I envision for Canada, is finding that balance without having to do that extent of an investigation every single time, which would not be achievable in our current system.
Thank you.
Thank you, Mr. Brock. Now to Mr. Anand Sangari for 3 minutes.
Thank you very much. And my question is directed at the superintendent. I'm just wondering if she can comment on, since PSEPA came in, if she feels that those who work in the sex industry have been protected, there's an increased protection for them, or if there are specific measures, including repeal of this act, that could ensure increased safety and security of those who are working in the industry.
It's a hard question to answer without specific examples. When I meet with community, I can say that the key to protection of sex workers is open dialogue and encouraging them to come forward to report crimes and to feel comfortable with the police. That is the largest barrier I see, more so than any of the criminal code offenses or any amendments. It's engagement with the community and building that trust that can be the largest barrier. I can't make any recommendations just offhand. We do recommend that the law remain the same from the CACP perspective, because we are using it effectively and we are managing with it as is.
We have heard from a number of different agencies and those in the industry that the application of the law is not being consistent and across the board, and I know you alluded to that as well. So how do we ensure that the application is consistent, and does it require us to revisit some of the provisions that will ensure that police Services can enforce it, or are some of these provisions completely unenforceable?
No, I believe the provisions are fine as they stand. And it's funny because when you talk about the enforcement of the law, it's not just these laws that are not enforced equally across the country. In my experience, many of the laws are enforced differently and to different extents throughout Canada. So I think that is the nature of our system, where different court cases and the case law in one province may not necessarily be binding in another. So without that, I just don't know how we're going to get a consistent enforcement unless we look at something like a national guideline on enforcement.
And my final question, do you think this this act adversely impacts Indigenous, Black, and other racialized communities?
I do not think that. And in fact, the Indigenous communities that I have met with here in Vancouver, they support this act, and they believe that it is valuable to protect the women in their communities who are being targeted by organized crime. Again, these are the higher level of violence and the offenders that we truly want to target.
Thank you.
Sangari, and thank you to the witnesses. We'll be now going into our next panel, and I believe I have the consent to go to 5:45, if that's okay. Seeing on heads, I'd originally think that should be good since we started late, and we'll run to that time. Our first witness will be Andrea Hines as an individual, also from Concentration des luttes contre l'exploitation sexuelle, Diane Matt, and Defend Dignity, Glendine Gerard. So each will have 5 minutes, and then rounds of questions will commence. So beginning with Andrea Hines for 5 minutes.
Thank you, Mr. Chair, and thank you to all members of the committee for this opportunity to join you today. My name is Andrea Hines. I reside in Edmonton, Alberta on Treaty 6 land. I have a diploma in correctional services and am presently a fourth-year student completing a BPA in governance law and management. The focus of my studies has primarily been violence against women and the impacts thereof. I'm a published scholar on commercialized sex and have spent nearly a decade interacting with a variety of individuals, agencies, and groups, such as those entering and exiting the sex industry, sex buyers attending the Edmonton Sex Trade Offender Program, healthcare providers, university students, politicians, as well as members and recruits within Edmonton Police Service. Prior to this work, I spent 7 years in Edmonton's licensed and regulated sex industry from 2006 to 2013. When I entered, I was 22 years old, drowning in debt, and had no viable education or skills. It was then that an ad in my local newspaper targeting women 18 to 30 caught my eye, saying adult entertainment, make $2,000 a week. It was an ad for a brothel, it was licensed by my city, and it appeared safe. Little did I know that men's entertainment would be something that would gravely impact my life thereafter. 5 minutes is not enough time to share with you all the indignities and trauma I witnessed and personally experienced being bought for sexual use over 4,300 times. It only took a couple months before I experienced a severe mental breakdown. After that, something changed in me, and I suddenly began to tell myself it was my choice, a job like any other, and that the harm was on the account of the owner I operated under or the specific studio I was in. I told myself it was a labor issue. I started identifying as a sex worker, something I can now recognize that I did as an act of self-preservation. As Canadian survivor Natasha Fowle stated in the Bedford Challenge, I couldn't admit that I was not there by choice. We couldn't live in our own skin if we admitted that. We needed to believe it was our choice. That mindset didn't stop the harm, though. At age 25, I built a licensed brothel of my own, convinced that better working conditions would make it safe for me and the other women. That regrettable decision revealed to me that the source of the harm is the men who buy sex, just as Trisha Baptiste accurately stated. Prior to then, I was under the illusion that I held power, but it was the misogynistic, sexually charged, and entitled men who had the power and used it to choke me, slap me, bite me, spit on me, verbally abuse me, remove condoms, secretly film me, stalk me, and more. Commercial sex is a patriarchal system of thinly veiled rape, which affords men the opportunity to use money rather than physical force in order to meet their demands for immediate sexual gratification. Sex work ideology is rampant and when not examined through a critical lens appears very palatable. If we hear these labor euphemisms enough, we eventually start to reframe and excuse what is inherently sexual exploitation. The next time that you hear the term sex work, examine the word exactly as it is. It will show you what it is. It is sex being placed in front of women being objectified, raped, and killed. There is a continuum of harm, and even at its best, sex work still entails the objectification of our women. The PSEPA is a well-written and balanced law. Decriminalizing the demand removes Canada's strongest tool for deterring and addressing exploitation. Repealing the purchasing offense, Section 286.1, supports market expansion. With no social deterrent, sex buying is given the green light. This money incentivizes exploiters to cash in, more agencies and brothels open, and pimping and trafficking increases as a result to meet an unfettered demand for women's bodies. Human trafficking is a specific offense and requires that a high threshold be met for charges. Repealing PSEPA means Canada has no tools for the coercion that is happening, the pimping and the profiteering. These are addressed through the advertising, procuring, and material benefit offenses, Section 286.4, 286.3, and 286.2 respectively. Full decriminalization is what exploiters and profiteers pray for. Canada is already failing to address the volume of victimization happening. What is our nation's plan to prepare for a potential mass influx of women into the sex trade and to provide the extensive supports that most of us come to require long term? Charities and NGOs addressing the subsequent harm are grossly underfunded and overwhelmed with requests for service. At the end of the day, whatever law exists, laws don't sit in the private rooms as the exchange occurs. More exchanges equate to more harm on a quantitative level because harm is inherent to the activity. We need to shrink the market and finally endorse and uniformly enforce this law. Only then can we do an honest review of its effectiveness. Thank you.
Thank you, Ms. Hines. Next to Diane Matt for 5 minutes, please.
Merci.
Thank you, and I thank you, the committee, for welcoming me. And I would particularly like to salute the women who came and testified before you at the committee, and particularly Andrea, who's with us here today. My group is an organization that supports women who are struggling with prostitution and its effects for over 15 years. We support some 200 women a year, and women and girls come to us for assistance. We help women who wish to get out of prostitution, and they also want to prevent other women going into prostitution, and that should tell us something. As we only have 5 minutes, I'll get right to the critical issue that Canada is facing, particularly the Justice Committee here now, which is to say, do we want Canada, to say that there's a right for women, or men rather, because they are overwhelmingly men, to buy sexual acts from women and girls, because they are the ones who primarily are bought? If the answer is yes, then we want to see a total decriminalization of this practice. The consequences for women and girls would be enormous. Countries like Germany, Spain, and New Zealand have made the choice and have different results. They all have exponentially higher number of men who want to buy these services, and even younger and younger men want to become pimps. It increases human trafficking, and some of those countries are even intending on changing their answers because they're seeing the impact of total decriminalization. If more men want to have access to these services, more women and girls will either have to accept or be made to accept that. And prostitution is an industry that we don't talk about enough. Men want it to be a right for them to buy these services, and a simple right to be a simple right for women. The most marginalized women, racialized women, immigrants, and Indigenous women are the biggest victims. Total decriminalization of this industry and the practice of buying these acts makes this tolerable and invisible. And we see that far from questioning the existence of such a reality, women coming from these groups are often instrumentalized by those who are lobbying for total decriminalization in order to defend this practice that is a patriarchal one by invoking the safety of women. And this is heinous. If the answer to our question is no, if you're interested in blocking this practice, you should look at countries in the northern regions like France and Sweden, who have chosen the equality model rather than the Nordic one. And the 2014 law was inspired by that. It proposes not just to prevent entry into prostitution and to question this practice, which is apparently the world's oldest, to support those who are struggling with prostitution and those who are in the majority who want to get out of it. We also would like to see through this equality model the Johns, that is, and the pimps, who they are the ones who have the real choice here, and they should be targeted. France passed its law criminalizing the purchase of sex acts in 2016, and they assessed it in 2020. I encourage you to read the reports that they have written on this. The evaluation is positive, and despite the fact that the law has not been enforced equally in every French department and that too little money's been invested to support, among other things, pathways out of prostitution, the evaluation is positive and the law upheld, if not reinforced. The Quebec government has already answered no to this question. It has an equality policy that affirms that prostitution is a form of violence against women. And this must be our starting point. It adopted a government strategy to combat sexual violence since 2017 and the new action plan against the sexual exploitation of minors. We count on you to refuse to decriminalize prostitution completely, despite the strong lobbying for it, and we need to choose to not support such practices that not only put women in unsafe situations, but is also against the access to equality for all women. We believe. Okay, thank you.
Questions? And next, from Defend Dignity, Glendine Gerard, please, for 5 minutes.
Thank you. I'm Glendine Gerard, the co-founder and director of Defend Dignity, a national organization which works to end all forms of sexual exploitation in Canada. I'm coming to you from the Mississaugas of the Credit First Nation. Thank you for the privilege of speaking to you today. Defend Dignity is strongly supportive of PSEPA and its objectives. We agree that denouncing and prohibiting the demand for prostitution and denouncing and prohibiting the profiting from another's exploitation by third parties are needed in order to deter prostitution and stop its harms. As part of our work, we have educated over 10,000 people across Canada about sexual exploitation. We remind them that prostitution cannot exist without buyers. We champion gender equality, and we look for ways to dismantle patriarchal attitudes that fuel the demand to buy sex. We are also researching the attitudes of sex buyers as found on a Canadian online escort review board to better understand the men who buy. These boards are online forums where sex buyers review and rate those they purchase for sex. Our analysis of comments from a Canadian sex buyers review board has found that number one, the most commonly searched for term is young. Buyers prefer young sellers. One reviewer states, and I quote, "More money does not mean more services. That's just the price of admission to enter a young hot girl's booty," end of quote. The second most searched term is a reference to a woman's body size. Some reviewers score women's body parts out of 10. Thirdly, racism and racist stereotypes are rampant on the review board. Discussing the pictures on one seller's website, one buyer said, I quote, "I wonder when I don't get a bum shot too, particularly for an ebony lady," end of quote. Lastly, trans women experience greater violence. In a discussion about prostituted trans women, one buyer said, I quote, I think we have all the right to choose who we are with sexually. Not disclosing, especially in advertisement, is deception, in my opinion, and can lead to dangerous situations. I don't condone violence, but it is just a reality, end of quote. Our organization also has a group of men who respond to online ads for sex and engage with buyers at the point of purchase, giving them information on the potential harms of their decision to purchase and sexual addiction resources should they want those. Our research findings and our engagement with sex buyers reveal their attitudes and actions can be harmful. Male sex buyers believe that men are entitled to paid sexual access to primarily women's bodies, and this payment entitles them to do what they want. Our laws are a teacher, helping to shape our culture. The purchasing offense must be kept in place to deter these harmful attitudes and behaviors. Defend Dignity also provides financial aid through our support fund to individuals in the sex industry or those that are seeking to leave it. To date, the fund has had 291 applicants and almost $200,000 has been provided in funding. Common needs are debt repayment, as pimps and traffickers often rack up exorbitant credit card or cell phone debt, trauma counseling, housing, dental, educational needs. Applications come from across Canada, 80 service providers, law enforcement, and support agencies. The applicants are representative of the large number of individuals in the sex industry who are there not by choice and who need the protection of this legislation. They are a key reason why we support PSEPA. We owe them much thanks for the information gleaned from their intake forms and the letters they include with their applications. You have a brief by Michaela Gray, who conducted an analysis of the data from the 2021 spring submissions to our fund. Her brief provides a summary of her findings. 53 applications were analyzed with the goal of better understanding the diverse experiences of individuals impacted by the sex industry. This analysis has been peer-reviewed and is about to be published in an academic journal. I want to highlight two significant findings from this research. The 53 applicants described their experience in diverse ways, such as prostitution, escorting, survival sex, and trafficking. Fully 96% of the women reported experiencing third-party involvement or trafficking at some point during their time in the industry. 36% experienced third-party involvement from gangs or organized crime. Regardless of how an individual described their involvement in the industry, there was fluidity of choice, exploitation, and coercion expressed in all of their experiences. For example, 9 women described their experience as independent, and yet 6 of those also said that a trafficker was involved at some point. Of the 34 who said they were in prostitution, 26 also said they were trafficked. The research found that individuals may self-identify their experience in different ways, and their involvement cannot be adequately conveyed in single-use terminology. Many described how boundaries were crossed and they were continually put in situations that they did not desire to engage in. Lastly, of the 19 who disclosed their age when they entered the sex industry, 12 were minors. 1 was just 2 years old when she was first sold for sex. The legislation is well named when it speaks of protecting our communities and our children. Based on the findings of this research, we urge you to uphold all provisions related to third-party involvement.
Thank you,
These laws are essential.
Ms.
Thank
Gerard,
you for keeping them in place.
Thank you. I will now go for my first round for 6 minutes to Mr. Morrison, please.
Thank you, Chair. And thank you for the witnesses this afternoon. I'm going to start with Ms. Hines. I want to really thank you for coming today, and it's so important for the committee to hear from someone with your background and having lived the life that you did, and I feel so sorry for what happened. I guess what I'd like to hear is how you could see PSEPA improvements so that we would be able to maybe help more individuals so they are not, I guess, brought into the sex trade. I just wonder if you could maybe elaborate a little bit, especially from your background.
Thank you. Thank you so much for that question. And I really want to highlight what Glendine has said. in that it is just part of the culture. That is part of our patriarchal culture here, especially in Canada. We view ourselves as this very progressive nation, and in many ways we are, but we are falling short tremendously on gender equality and sex-based equality. And I really think that the law is sound. And I think that the only area that really needs some maybe perhaps tweaking is Section 213, because we know that our most vulnerable sex sellers who are on the streets, that are dealing with complex health issues, untreated mental health, intergenerational trauma, addiction, they are the ones that are being targeted by that provision of PSEPA. So I really feel, and please, I'm not a lawyer, so I can't say exactly what the answer is, but I can say that there is harm happening to women, and that in that regard, we are still targeting them in some facet. And we need to completely remove all barriers that they face. And that also includes expunging all records of any historical or current convictions that have been placed upon sex sellers, and also just really highlighting where the harm is coming from. And again, that is from the culture and from patriarchy within our masculinity. And I really think that we have wonderful men in Canada who are doing great things, but we have a social rot here as well that is taking over, and we're seeing it heavily. Sex work ideology is infiltrating every single facet of Canadian women's lives. We can't walk down the street without being procured for sex. I'm with my children in a stroller, jogging in my neighborhood, and men are pulling up and harassing me. And at times I'm even with my husband. It's no holds barred, and it just feels like we are going to be thrown to the wolves, and that it's going to be open season on us. And we really have to work on changing the narrative that women deserve better than to be purchasable commodities for sexual consumption.
Okay, thank you. What would you say to people who are asking or saying that we should strike down PSEPA and not have it at all? What would you say to those people?
I think it's a very short-sighted vision. I think, when we look at it from a very, very micro lens, to some people it might make sense, right? She says she wants to sell sex. Who are we to infringe upon personal freedoms? But we need to start looking at the collective good, and especially the collective good of womanhood here in Canada. Because again, we know that many of us are being subjected to male we are being subjugated to male depravity, essentially, and it's very, very hard. It's very defeating. And I think that we need to take the zoom out perspective and recognize the activity for what it is, which is coercive sexual access. It is not work. We have to look at where the lines between agency and submission exist. And I really don't think that many of us, I know I wasn't operating with a lot of agency. Sure, I didn't have a gun put to my head. I didn't have a pimp or a trafficker, but poverty was my pimp. And it's the case for so many women. And because we are so reliant on that, because materially we are subjugated in Canadian society, we lean with our abusers. We side with our abusers. We smile in the face of our abusers as they abuse us because we need that money. And it's not fair to do to women. So yes, this is a huge problem. It is a multifaceted problem, and we need to tackle it from all different angles. There is so much work to be done, and we can't just abandon women and just put a green light on exploitation and think that the problem will somehow solve itself. It won't.
Okay, thank you so much. And I wonder, Ms. Gerard or Ms. Gerard, I really was intrigued with your report on trying to get a better understanding of the sex trade and the different reasons and rationale. And you were kind of cut a little bit short on your time. I know you were rushed a bit. I wonder if you could expand a little bit on some of the research you're doing. It would be quite valuable.
Yeah, thank you for the question. The research that we've undertaken really is meant to help us understand the full impact of the sex industry. And so some of the questions that we framed our research around were: what factors led an individual to engage in the sex industry? How does the involvement in the sex industry impact an individual's emotional, mental, physical well-being, regardless of how they personally identified their experience? What was the involvement of third parties? As I highlighted to you, was it a friend? Was it gangs? Was it a trafficker? What was the third party involvement? And then what enables an individual to choose to exit the industry and or stay out of the industry? So those are the things that we looked at. I can certainly tell you that how the sex industry impacted individuals' physical, emotional, mental well-being was all negative. There's all sorts of quotes that I could read you from our research from these 53 individuals. Not one of them was untouched physically, emotionally, mentally. The violence was rampant. All sorts of horrific things happened. And I hope that you caught the fact that out of those 53, the youngest person was only 2 years old. This individual was trafficked by her family, which is sadly a common occurrence. And there's just negative impacts that we surfaced throughout this research.
Thank you so much.
Thank you, Mr. Morrison. And now 6 minutes to Madame Briard.
Thank you, Mr. Chair. Ma question est pour...
My question is for Ms. Matt. Concerning New Zealand, the members of the committee here heard that over the 5 years following the decriminalization, there hadn't been an increase in the number of people working in the sex industry, and that working conditions for those people had improved. So I'd like to hear you speak to that. In fact, the war of statistics is always somewhat special. The contacts that we have with women in New Zealand shows a very different portrait. We were talking earlier about Indigenous women in New Zealand, Maori women, even created an organization to fight against that choice of their society because they speak indeed of an increase of this becoming just more normal in New Zealand society and in their communities, and the fact that young Maori women are more and more drawn into prostitution. So as I was saying earlier, the problem is complete decriminalization of prostitution, and that is New Zealand's the only country in the world that chose that option, makes the harm and consequences of prostitution in general completely invisible, and particularly for indigenous and racialized women. So that's the data that I have. I've seen that there's been an increase in human trafficking also, because there's an increase in New Zealand men who want to buy sexual acts. There's sexual tourism that's increasing there. And indeed, it's already been found to be the hub of human trafficking. So you can imagine what that would be if indeed Canada chose to decriminalize prostitution completely as well. So I think we're inviting you, I invite you to look at this issue of prostitution not just as one where you are just improving the conditions in this work. You have to look at who's being drawn into it, what is the access of safety and security and dignity and equality for all women. And I think that you have a responsibility that is enormous currently. You're holding in your hands the possibility of indeed saying to Canada that we are making a priority of prostitution that is tied to equality for all. Whereas what you've heard, particularly I think from a very powerful lobby that wants to see a complete decriminalization in Canada, you've heard the story of those that we want to speak well about, but they're made invisible. The majority of other women and girls who are in situations where they're brought into prostitution, primarily by poverty. We're coming out of a pandemic that is not over. Women have been getting poorer and poorer in Canada since 2020. Do we know what that means in terms of getting into prostitution? Clearly, around the world, there's an industry that really benefits or profits from this economically, and that is in fact awaiting a decision like this. Unfortunately, some of you have the idea that we'll get rid of these laws because it prevents us from using these services, and we're just believing that somehow we don't have a role to play in this to put an end to this practice. Thank you. And on the website, we can see that the Canadian law has seen a change in paradigm at the same time by condemning the purchase of these kinds of acts, but also at the same time going after people who are working in this industry, as you have said. So how does this really play out on the front lines, and how can we look at changing the law to make things better? Well, for us, the most important and fundamental change that the 2014 legislation brought was to change the crime of purchasing sexual services and making it a crime against the person, and just to say that not looking at it just as a transaction between consenting adults. That's the most important thing, I think. The current problem, I believe, is that we're only looking at one part of the criminal code, but the objectives and the inspiration of the Canadian legislation really is part of a model, as I said earlier, that covers preventing people getting into prostitution, but also protecting little boys. Little boys aren't born into this world thinking that they can buy sex from women. They aren't born thinking that they should be pimps. They learn these things. And we were talking earlier about culture and the media. This is just becoming more normalized, and this is what we have to fight against. The problem currently is that, yes, we can concentrate on certain parts of the criminal code, but we don't believe that anyone should be criminalized wherever they are found when they're in a situation where they're being sexually exploited. That should be perfectly clear. And in the models that we've seen as being satisfactory around the world, there's no criminalization that's tolerated of women, and because it's primarily women. And it's clear that on top of all of that, we have to ensure that there are prevention programs and support programs.
Interrupted. Hoping you'll be able to carry on one of the future questions. Mr. Fortin, for 6 minutes.
Merci, Monsieur le Président.
Thank you, Mr. Chairman. Well, Ms. Matt, you were on a big trajectory there. But I'd like to hear what you would say about something. You said that you like the equality model rather than the Nordic model, and you said that Quebec in 2007 drafted legislation in this regard. And I'd like to hear a bit more about that from you. So what is the equality model, and what has Quebec done to turn towards that model? Well, in fact, in 2007, there was an equality policy that, to my knowledge, doesn't exist anywhere else in Canada, that was adopted, and that, as I said, that really anchors prostitution in an issue of equality. That is to say, a society in which women and girls and boys can be bought and sold and rented, use the words you wish, but it's a society where equality for all is impossible, if that's the case. So in 2007, Quebec made huge progress. And I would also add that they haven't done enough since then, but the spirit of it remains that when we look at prostitution, we're looking first and foremost at this as a practice that is socio-sexual relations between men and women. And we have to start there to analyze what it is, not just looking at the harms and the fact that it bothers people in certain neighborhoods, or that we don't want men to catch venereal diseases and bring that back home. We're changing the focus with the whole issue of equality. And this model, as I said, takes it as a given that we have to change people's mentalities, that we live in a patriarchal society, a society that effectively means that some women's groups are particularly targeted, and that we must indeed change the practice as such. And from that point, as I said, we can use I'm sorry, Ms. Matt, we have very little time. I don't want to be impolite, but I'll have maybe 2 or 3 minutes left. Could you tell me a bit more, and if not, we can move on to something else, but about the impact of the equality model? I understand what it is, but what is it exactly? Concretely, what does it change in terms of legislation? What are we doing? Well, in terms of the legislation, it demands that we attacked the whole purchase of sexual services. We attack pimping and procuring and the groups that benefit from prostitution. But the main change is to say that men do not have the right to buy sexual acts. It's as basic as that. The impact of the law is. Thank you. I'm sorry. I have another question, if I may, Ms. Matt. Before we wrap up, I have one last question for you. Some witnesses talked about organized crime that was involved in the sex industry, and that's very worrisome to me. We already know that we have problems with weapons trafficking and other problems with criminal organizations. But in terms of the sex industry, you, in your practice, I'd like to hear you on this point. What have you found? Have you seen that there's a great demand for criminal organizations that are benefiting from and involved in the sex industry, or is it marginal for you in Quebec? Well, the police could answer that better than me, I imagine, but very clearly, the women with whom we work, some are really stuck with gangs of organized crimes, like it exists in Quebec as it does elsewhere in Canada and the world. But also, women are brought into the sex industry by this becoming just more normal. Some friend said, oh, this is an easy way to make money. Or some guy tells her that he loves her, and then all of a sudden he's talking about the fact that he has money problems, he needs money, and so he sends her out to work, to prostitute herself. And, you know, I was really struck by the person who spoke in the previous panel about we're actually seeing young boys as young as 12 to 15 who are trying to convince girls to prostitute themselves for them. So have you seen that in your practice? 12 years old, I've never seen that, no. But young men, that's one of the things we've seen because it's becoming more accepted and normalized, means that indeed young men are launching themselves into bringing young girls from their high schools to sell sexual acts, and they collect the money. Yes, we are seeing that currently. And what would you propose to? How would you propose that we fight against that, to discourage that and not facilitate the entry into the sex industry by these young men? Is it education, I imagine? You talked about a change of culture. Are there tangible things and legislative steps we could take to stamp this out? Well, we start by looking at the 2014 legislation, and we give more means to be able to try and change people's mentality and to do more outreach and more awareness for young women who are thinking of going into it and those who want to get out of it. It is effectively the best way currently is to strengthen the law and to ensure that no women are criminalized. No one across Canada who's selling these services.
To interrupt you, sorry. Sorry, we have to go to the next. For 6 minutes to Mr. Garrison.
Thank you very much, Mr. Chair, and I'd like to thank these witnesses for their appearance today. Their testimony has certainly been crystal clear, and I'd like to thank Ms. Hines for drawing the committee's attention to the problem of criminal records for those who have been involved in sex work previously. Given that we're already over time, I am prepared to forego my time today.
Thank you, Mr. Garrison. I appreciate that. We'll next go for 2 4-minute rounds. For Mr. Brock for 4 minutes, and then we'll do 4 minutes for Ms. Dillon and end it after that.
Thank you, Mr. Chair. I want to thank the witnesses this afternoon for your testimony and cooperation in answering a multitude of questions. So firstly, to Ms. Hines. Ms. Hines, thank you so much for your testimony today and your courage to come forward, surviving a dark chapter in your life, but being extremely resilient and now being an advocate, a very strong advocate against the industry. I was remarking to myself about one of the latter comments in your opening statement that you wanted to ultimately shrink the market. And one of the overriding goals of this legislation is to decrease the demand. So I'm going to give you an opportunity, Ms. Hines, if you could perhaps elaborate within 30 seconds or so as to what you meant by shrinking the market, and if you have any ideas on how to implement that.
Great, thank you so much. Yes, shrinking the market should be our priority. That will take out a substantial amount of sex sellers who are not there by any means of actual choice. Any policy that we implement is either going to expand the market or it is going to shrink the market. And when we look at New Zealand, which we often do, to me, that's comparing apples and oranges. New Zealand is an island in the Pacific, approximately 5 million people. Canada is a population approximately 8 times that size, sharing 9,000 kilometers nearly of border with America. The American population is over 330 million people, and their adult male population is more than double our entire population here in Canada, meaning that there is more than 100 million adult men in the United States. So when Kathy Peters said that we have the potential of becoming America's brothel, she was spot on. None of us have a crystal glass ball that we can look into the future to see what will happen with any changes that we make. But we have to look at Canada as its own entity, as its own nation, and say, what risk are we willing to take, to risk women's livelihoods and safety? And I think I also do want to point to the effectiveness of Edmonton's sex trade offender program. We have a wonderful low 1 to 3% recidivism rate of rearrests of men who come and attend the 8-hour program. It is a great program that I have been very fortunate to speak at for the last 9 years. I have seen tremendous growth in many of the men who come in. And I want to say that I believe personally that the industry in many facets is duly exploitative. Most men do not want to purchase sex. Most men are also a victim of the culture that tells them that their masculinity requires them to be sexual consumers, requires them to consume women's bodies without any foregoing thought of who they are as an individual and anything along those lines. So I really think that when men are given the opportunity for education, when they are allowed alternative measures programs, many of them do turn the corner and they do not continue to exploit women. And they always have said to me, I had no idea. I really had no idea. I took it at face value. She told me she wanted to be there. I didn't see a pimp or anyone behind her. And I thought that it was no harm, no foul. But I think the problem is that people equate it to healthy, natural sex, because that is the type of sex that most people, fortunately, have participated in. And I think that whenever we look at transactional sex, it is not in line with what we know to be authentic sexual consent. One of the cornerstones to sexual consent is that it is freely given. And the very essence of the fact that we are doing this huge amount of economic coercion in order to suck marginalized and vulnerable people into the industry speaks to what is needed for them to play along and smile, like I said, in the face of their abuse. So I really think that we need to have a strategy that creates an interministerial body that works with the status of women, with public safety, with wage, and with justice, because this is such a multifaceted issue. It involves intimate partner violence, economic inequality, trafficking, all these problems. So this is a multi-decade strategy that we need to do, and we need to stay the course. Trisha Baptiste said we need more time, and we do, but we also need more effort. We are not given effort, and we can do better by Canadian women and girls. So I think education is cornerstone to it. The feds need to be giving the money to the provinces so that we can have some curriculum being put into all of our educational institutions, particularly starting in grade 7, because we are seeing these young men become exploiters. So
thank you.
Thank you.
Thank you. And now for 4 minutes to Ms. Dillon, please.
Ma première question,
My first question will be for Ms. Girard.
And marginalized people in the ads that were in your testimony. Can you please tell us if there's a huge difference when it comes to helping those who are marginalized, when it comes to law enforcement, and when they go to the police to denounce a crime, are they mistreated when they are presenting themselves there? Do they not go because they're afraid of criminal charges themselves? If you could please talk a little bit about that. Thank you.
Well, I would say that out of our Survivor Support Fund, about 17% of our applicants are Indigenous people. We don't ask that specific question, what their experience has been with, like with the police. I can only answer that question anecdotally from my own conversations with different survivors who are Indigenous or BIPOC. So I can respond to the question that way and say that, yes, there certainly has been experiences that they may have had with the police that have not been good. Conversely, there are some that have had good experiences with the police. And I really want to speak to that, of how important it is. And so if we're talking about changes to the legislation, would strongly encourage that a training component for all aspects, all parts of our justice system must be included. We, as I mentioned, have trained 10,000 people across Canada, most recently at a summit, a Canadian Sexual Exploitation Summit, where we had a whole day training police, Crown attorneys, judges, whoever wanted to be part of that training. And part of that training was to hear from Indigenous voices and to share their experiences with the police of the things to do and the things not to do, and some of the challenges that they have faced. And so absolutely, I don't deny that there has been challenges at times with Indigenous people with their experiences with the police, but I think that better training is what is needed, and I do see that as possible. And we were very encouraged to have about 75 police, Crown attorneys, and judges take part in the training that day last May. And they were all very supportive of the PSEPA over the law that you're currently reviewing, and wanted just to learn better how to implement it and how to enforce it.
Thank you very much for that. And you also spoke a little bit about the research report, and then you ran out of time. Were there any suggestions in the report or anything those who responded wanted to see when it came to legislation?
Yeah, but again, we didn't ask questions about the legislation, but I can tell you on behalf of those that I believe we are representing as we share the results of this research, many of them spoke to the harms of purchasing, how buyers were violent. And so we would certainly speak in support of keeping that provision in place. We need to have the 286.1 purchasing provision stay as it is, based on what the research tells us, that it's buyers and it's pimps and traffickers, it's exploiters who are causing the violence. And we believe that the law it protects those that are experiencing that kind of violence.
Thank you. Thank you, Ms. Dillon, and thank you to all our witnesses today. You've enlightened all of us in all your aspects of it. So I'll now conclude the meeting, and we'll adjourn until next time.